You have legal questions. Aimee the Attorney has the answers. Welcome to today's show. And here's Aimee.
Hello, and welcome to our show. Today we have Mark Ellebracht, the Honorable Mark Ellebracht. He is a state representative north of the river. Why don't you tell people where do you represent people? What's the locations?
Well, it's my House district that I was elected to in 2016 is composed of the neighborhoods of Choteau Heights, Holiday Hills, Gracemore, about half of Maple Park, and then most of Liberty, all of Clay Como, and all of Pleasant Valley. That's what the 17th House district is made up of.
Okay, so let's go back to when you began the work for running. Tell us when you initially run, because he was successfully elected in 2016, but had run before, and I want to hear about the whole path.
Well, it was a long journey. So I graduated from law school in 2010, and upon graduating from law school, I was asked by the Clay County Democratic Party, the county-wide party, to run for the House office that was opening up. Back then it was House District 34. And that was prior to the redistricting of 2012. So I ran then because I was asked to run. It was a good opportunity for me to meet a lot more people in the community as I was coming out of law school. And it's something that I've wanted to do in terms of getting involved in politics. It was something I'd wanted to do since I was a small kid. And when I got out of the military, I got an opportunity to work for Ike Skelton in Washington, D.C. And that only sort of, fanned the flames of wanting to be involved in public policy. So when they asked me to run, first of all, I was flattered that they would ask me. And second of all, I was eager to do it. So in 2010, we ran, did not win that year. That was a tough year for Democrats to win. It was an off year after Barack Obama had been elected. And so there was a lot of anti-incumbency votes in that off year. We ran again in 2012 and lost in 2010 by something close to 10 points. In 2012, lost by 1%. In 2014, we ran again and lost that election. We were 73 votes off on that one, which would have been very close to getting a new election because 72 of the votes had been disqualified. So we were technically one vote, or would have been one vote away from getting a new election. And then in 2016, I was asked to run again. At that point, I had built my practice up, and I had been practicing as an attorney for 8 years and was involved in several trials with various other attorneys around town. Had been involved in working up and trying first degree murder trial that I had ever done. And I ran in 16 and won in 16, and I was reelected in 2018. So it was kind of a longer path than a lot of people, but Liberty makes up about 60% of the population of that district. And the last time they voted for a Democrat in a legislative race as a community in terms of percentage-wise, the last time a Democrat had won a majority of the vote in Liberty was 1992. So it was close to a 30-year run there of Republican candidates out of Liberty before we finally turned it over. So it was a long path, and it took a lot of work. We knocked on a lot of doors, and we had to go to a lot of different meetings and fundraising events and things of that nature. But my team, who I think very, very highly of, stuck with it. And the folks that believed in me hung with me, and we, finally got across the finish line.
It's tenacity, something you definitely want in a legislator. So that is fantastic. I want you to talk basically about the position of state representative. I want you to talk about what exactly that means. And I want you to talk about, I just want you to talk about a state rep and what a state rep does in Jeff City. Okay. Just specifically what your job is. And this is also with the knowledge that the Democrats are not in the majority, so they're in the minority, so that the way his job is might be a little different than somebody that is in the majority. I'm not sure. That's why we're asking him. Yeah. So tell us about the work that happens in Jeff City when you're a state legislator.
Well, we go down just the basic sort of logistics of it first. It's the easiest part to explain, I think. We go down in January. Usually it's the first week of January, and we are in session from the first week of January until the second or third week of May, depending on some different factors that I'm not sure anybody really truly understands all the way, but usually we don't go past May 18th. And then after that, we go back into our regular jobs. So I'm an attorney. There are other people that I serve with that are that own grocery stores. They go back to their grocery stores. There are people that are construction workers. They go back to work in construction. There are pipe fitters and plumbers. There are school teachers. We run the gamut in terms of employment, and everybody goes back home after that May 18th date. Now, while we're there, we have two main roles. One of the major roles, at least from my perspective, being a member of the minority, one of the major roles we play is to serve as a liaison to state departments. So that, for instance, the Missouri Department of Revenue, if they're struggling to get your tax returns out in a timely manner, you can contact my office and we will get somebody on top of it and try to figure out either why the income tax returns aren't being completed in an adequate amount of time, or hopefully get you a result and get them back for you in an adequate amount of time. So anytime there's a state level department that's a constituent is having an issue with, they could contact my office and we will work as a liaison for them to be able to get hopefully a better result in terms of what they're looking for. The other role we play, other than being a liaison for our constituents, is to serve on the committees and to vote on legislation as it comes to the House floor. So individual members are assigned by the Speaker of the House to certain committees that they might be on. There are special committees, there are standing committees, and then there are joint committees. Joint committees are committees between senators and representatives. Special committees are committees that are formed by order of the Speaker. During any certain period of the legislative session, the Speaker has the authority to establish a special committee. So that last term, I was on what was called the Special Committee for Litigation Reform. It was more or less the Tort Reform Committee, but that was where a lot of the civil so-called tort reform bills were being passed or being sent to. And then the standing committees are committees that have and will continue to exist for probably as long as we have the system of legislation that we have now. So that, for instance, the Education Committee is a standing committee, Agriculture is a standing committee, and the Judiciary Committee, which I'm on, is a standing committee. We also have Economic Development, which is a standing committee. I'm also on that. As many people know, insurance, the insurance industry is a state-regulated entity, not a federally regulated business. And we have a committee on insurance policy that I sit as the ranking member on. So we sit on those committees. Bills are filed. After they're filed, they're referred by the Speaker to one of those committees that does the initial vetting. We read the bills. We think about the bills. We discuss the bills. We hear public input on the bills. And then eventually we vote on whether or not the committee thinks the bill should pass from our committee to a Rules Committee. And the Rules Committee is responsible for basically doing just the fiscal impact of the bill. So that, for instance, if we want to make a law change and it might end up having an impact on the state budget, that Rules Committee is assigned with the job of figuring out what the impact on the state budget would be. And that's basically their exclusive authority. And then from there, it gets referred back to the floor. If the majority floor leader wants to have the bill called to the floor, he will recognize the representative that initially filed the bill, and that representative will have the opportunity to stand up, have the bill introduced, have the bill titled, and then proceed to having the bill perfected, which is an opportunity for everyone on the floor, all 163 members of us, to offer amendments and see if we can get them on or not. And then third read. Once the bill's been third read, then that's when the Speaker sends it over to the Senate, and the bill begins its whole process all over again on the Senate side. So the two roles of the state rep, to be a liaison with our constituents for the state government departments, and to go through the process of legislating to change the public policy of the state of Missouri.
What are the what do you get the most phone calls about for constituent services?
It runs the gamut. We had in this past spring, late winter and early spring, we had a telecommunications company coming through my district that was running fiber optic cables, and in some cases, constituents had their property was being dug up. Some property damage was being incurred. It was brought to my attention that that was happening because the telecommunications company never really notified my office that they were going to be there. So it kind of came out of the blue. And then, I drove through the district, made note of all the places that they were, needing to sort of clean up, fix the things that they were doing, make repairs to people's personal property. And because they are a publicly regulated private industry, in other words, they're regulated by
utilities, like the Board of
Public Service Commission.
Public Service Commission. Okay.
So because they're regulated by the Public Service Commission, that's a public entity, more or less, and they could contact my office. I would liaise with the company that was installing them and make sure that they would come back and fix the property as necessary, because if they wouldn't, then they would have to answer to the Public Service Commission. The Public Service Commission has the authority to levy fines, and they're the ones that regulate who gets the next contract with the state in terms of private companies providing public service such as that. So having a bad track record of taking care of people, taking care of constituents' property might interfere with the company's ability to go back in and get a new contract next year too. So that was one of the ones we got calls on frequently this last year. 2 years ago, Gracemore was having the neighborhood of Gracemore, which is that neighborhood of Kansas City that sits right below the Claycomo Ford plant, just south of the Claycomo Ford plant. They were having a very serious problem with power outages. I was able to contact KCP&L and get KCP&L to commit to replacing the grid. And last summer and this summer, they have experienced a dramatic reduction in the number of power failures that they've experienced over the summers. 2 summers ago, they had, of the first 7 weekends in summer, and I count the weekends in summer as from the day school lets out to the day school starts. So of the 7 weekends in that time span, 4 of them, the residents of Gracemore had experienced a power outage of 12 hours or more, which is absolutely unacceptable under any circumstance, especially in light of the fact that many of my constituents require power for things like refrigerating medication, for dialysis machines, for infants nursing who have their breast milk in freezers, things of that nature, where people absolutely have to have power. Spending 12 hours more without power is not something that any of them should ever have to experience, especially if they're paying their power bills on time. So got in touch with KCP&L, got them to commit to replace the grid and to making the changes that they needed to make in order to provide a better service, and we were able to successfully do that. That was the big call 3 years ago that most people were calling about and concerned about. Other than that, we have a regular group of people that call in about their income tax returns being delayed. We have a certain number of people that will always call and make suggestions on legislation, things that they think need to be changed, which is always helpful. I like hearing from constituents, especially if they have what they think is a good idea or what is a good idea on a law change that we might want to see. So I encourage that kind of stuff. That kind of contact is important to me.
All right. So this is something that I learned via a cartoon, but I would like for you to explain how a bill, well, actually, let me ask you this. About how many people do you represent? Do you have an approximate number?
An average House district size at the time they're formed after the census is about 38,000 souls. And depending on your voter turnout, it's higher or lower. So that my district has a relatively higher turnout rate than a lot of the average turnouts of some of the districts. Depending on the race, it can go anywhere from between 13,000 voters in an off year to 17 to 19,000 voters in a presidential year. So it varies based upon what year it is, and it varies based upon the energy or enthusiasm of the voters in the particular district. But every state representative has about 35 to 38,000 souls, people that live in that district. They might not all be citizens, they might not all be registered to vote, but that's basically how they allocate representation.
So 35 to 38. And are the state legislative districts drawn according to population, but not according to like the actual geography of it? It's more of population.
Well, that's a good question, because there are a number of factors that go in. So that the state legislature tries to protect communities of interest. They try to protect certain municipalities if they can. In other words, they try to keep municipal units intact where it's reasonably possible to do so. They try to allocate the lines along communities of interest so that if we have, for instance, predominantly Hispanic community or a predominantly Latino community, if we have a predominantly Black community, if we have a predominantly working class white neighborhood, so to speak, they work to try to make consistent districts so that they're a little bit easier to manage, a little bit easier to sort of predict. It's also important to note that in those majority minority districts, it's in an effort to make sure that the people that get elected to represent those communities are members of those communities. It's in a lot of cases after the 1964 Voting Rights Act, there's been a very strong commitment towards getting people a seat at the table, because oftentimes it's not enough that they have somebody that votes the right way, but that a member of that community ought to be at the table, ought to be a part of the legislative process as well, because those perspectives are important. And so there are a lot of different factors that get considered, but at the end of the day, the districts all have to have roughly the same number of constituencies in them.
I did not know that. That is so good to know. Okay, so let's just talk really basic. How does a bill become a law?
Well, the most basic way that a bill becomes a law is that we vote for it. The process, and I say that kind of tongue in cheek, right. That's what happens every step of the way, is that a bill has to be voted on almost every step of the way. And I will give what I think is a really great example of a bill becoming a law was House Bill 192 this year. That was something that a representative named Bruce DeGroat filed, and its original incarnation, the bill that he and I sat down and wrote together, was 1 page long.
Is he a Democrat or Republican?
He's a Republican from the St. Louis metropolitan area.
Okay.
And he and I both are trying to work towards smart criminal justice reform so that we can sort of protect the interests of society and a good and well-ordered society and communities, along with being fair and smart in how we address certain bad acts committed by people in order not to wreck folks' lives, to allow them the opportunity to get back on track and back on their feet. And House Bill 192 is, I think, originated as a bill that started out really well in those terms. Is basically we were going to eliminate the idea that a warrant could be issued to compel a person to pay a board bill back to a sheriff's department. It was a very simple 1 page bill. It just said, more or less, in layman's terms, it said that a court can't issue out a warrant to satisfy a board bill owed to a sheriff's department.
And a board bill is?
A board bill is the bill that's incurred when a person enjoys the warm and loving hospitality of their county sheriff's department. In other words, when you get picked up and put in jail, in your county jail, every day that you spend there, you'll be charged for your stay in that county jail. That's been a part of Missouri criminal law since probably 1854. Board bills are a very old part of Missouri law. They didn't used to cost $54 a day, but that's sort of what they've become. And the bill is designed to compensate the people of the county who built the jail for the guards' time, the meals, the laundry, the electricity, basically the same things that you would pay a hotel bill for, you're paying a board bill for back to the sheriff's department. But what was happening was, in some cases, people were being released on probation after they'd spent 10 or 15 days in jail or 30 days in jail. Or in some cases, they were being sentenced to 30 days in jail after a guilty plea to some kind of a petty municipal or misdemeanor charge. And they would have a board bill that they would owe back to the county for their stay in the county jail. And failure to pay that bill, which happened pretty frequently because a person had just spent 30 days in jail and they didn't really have a job anymore, would result in the court issuing a warrant and that person being picked back up. Now, in a lot of rural communities, there's only one law day a month, which means that if you got picked up on the 15th of the month and the law day was the 10th of the month, you sat in jail from the 15th of the month until the 10th of the next month, and you incurred another 20 days worth of board bills for previous board bills that you couldn't pay. And some attorneys who have been experienced in this will know exactly what I'm talking about. Bruce DeGroat, the representative from the St. Louis area, and myself both picked that as an issue that we thought was a really good one. We could address it and just say, look, if you owe a board bill back to a sheriff's department, the sheriff's department can file civil process and recover the board bill in the same manner that a hotel that you owe money to would recover their fees. Right? We thought that was fair, and we thought that that kind of breaks the cycle of people getting picked back up for money owed that they couldn't pay, that was not designed to be punishment for the crime they committed. In other words, it's not a court fine. It's just money owed for their stay in the county jail. Because in those situations, I think most people would agree that their time is their punishment. The 30 days that they were sentenced to is the adequate punishment under the law. And then the court costs and the fees are justifiably owed for the process of having to go through that. Whereas the board bills aren't necessarily, and even if they were, there's an easier way for everybody and for society on the whole for those bills to be recovered. And it does not include having them go back to jail for us to pay for them for an even longer stay for bills that they couldn't pay in the first place. So we started that bill. It was a one-page bill. And we filed it in December. We pre-filed it. And we had it read in committee very early on in the legislative process. And it went from our committee to the Rules Committee. It was amended to include a couple of other things. There were some language tweaks that both Bruce and I were okay with. We didn't really like it. We thought our idea was good the first time we wrote it because we took several days kicking it back and forth in an email, but there were some other state reps, and that's part of the process. They wanted to make little subtle changes, and that's fine. And then it went to the floor of the House for the first time, where it was further amended. Most of the amendments that were made on the House were fair or were in agreement so that we could get more support behind the bill. And that happens quite frequently, where other people's smaller amendments are added onto a bill as kind of a vehicle, where somebody knows that the idea that they have isn't really substantial enough to be a standalone bill. They can add it on as an amendment to somebody else's bill that's going, and thereby generate support for their bill through support for our bill. So we add in. Politics is about addition. So we add in more supporters of the bill, and we get it passed. And we got it passed off the floor, and it got sent to the Senate. And in the Senate, it started that whole process over again. And the Senate read it in committee, and they had several ideas for changes that they wanted to see. Some of those ideas were not acceptable. Some of the ideas sort of undermined the whole purpose of the bill in the first place. And we were able to effectively keep some of those ideas off in the committee process, but some of them went back on. So it went from the Senate committee to the Senate floor, where the bill was further amended. Some of the bad ideas that were added in the Senate committee came off of the bill again, which was a good thing. And then some folks added in other smaller amendments, like they did in the House side, to get the bill across the finish line, and it came back to us. So what started out as House Bill 192 became the Senate substitute for the Senate committee substitute for the House committee substitute for House Bill 192. And it went through that entire process, and it took it about 5 months to get there. And it was what started out as a simple bill that would have prevented people from having warrants issued for failing to pay a board bill, to changes to whether or not judges should be bound by mandatory minimum sentencing. It removed that provision, so judges are no longer bound by mandatory minimum sentencing. It added a $10 surcharge to every civil process, regardless of whether a sheriff's department does it or whether a deputy or a private process server does it. And it changed the language with regard to whether or not a court could set up a traffic court in a county to address the DOR refusal dockets. It's what attorneys call them. Basically, when a person refuses to do a breathalyzer or submit to a chemical test after they've been suspected of driving under the influence, it now allows courts to set up separate traffic courts that are allowed to deal with those refusals specifically, so that the associate circuit courts or the circuit courts aren't directly burdened by that additional docket load. So it did a lot more than what we started with. Some of what it does is, I think, good. Some of what it does, we'll have to wait and see what the impact is on the folks that live in Missouri and how it affects the practice of law in Missouri. So that is how a bill becomes a law.
And then Governor Parsons signed it.
He did sign it. He signed it last week, and in its entirety. The governor, contrary to what some people might think, Missouri's line item veto power for the governor in Missouri only attaches to budget bills. It does not attach to policy bills that regard other portions of law. So the governor must sign or veto an entire bill. And then we go to veto session in September, and any bills that were vetoed by the governor get reviewed by the House and Senate. And if we can muster up 2/3 votes in both houses, we can override. It's 120 votes, I think, is 118 votes is what's necessary in the House in order to override the governor's veto. I doubt very much that that's going to happen this year, considering that the governor and the supermajorities in both the House and Senate are all of the same party and all of the same sort of mindset when it comes to the priorities of their legislative agendas.
Okay, that gives me two questions. Did Governor Parsons veto any bills this session?
He did. He vetoed 2 bills this session. And quite frankly, there were bills that I didn't have an awful lot of interest in. So I'm not quite sure which ones they were. There wasn't even, as far as I know, if a press release went out on which bills he vetoed, I don't remember seeing it.
Okay, but so there will be a veto session.
There will be a veto session, and we're constitutionally required to have a veto session, whether there were vetoes or not. But if there were no vetoes in those situations, we show up, we clock in, and usually we turn around and go home. On issues like this, the Republican supermajority will know whether or not they have the votes to override a veto or not. And if they know going in that they don't, they will usually adjourn the veto session early as well, because if they don't have the votes to do it, or if they're nowhere close to having the votes to do it, there's no sense in everybody sticking around and basically getting per diem for a week when it's not necessary, and we can all go back to our we can all go back to the jobs that we have when we're not state legislators.
Okay, so you mentioned a Republican supermajority, or you didn't even mention Republican, but supermajority, which at this point in time in the state of Missouri is held by the Republicans. I want you to explain what a supermajority is, and I also want you to explain when you're in the minority in a supermajority, what you have to do. And it sounds like you've already explained a little bit about that with the board bill to get your priorities passed, to get your district's priorities passed. How do you do that? But first, explain supermajority.
Sure. A supermajority is the number of people required to override a governor's veto. So in the House, I think it's 118. And then over on the Senate side, I believe they have 34 Senate members. So that would be something close to 20. And if they can do that, the governor's veto is basically overridden and the statute becomes law by virtue of the fact that the state legislator voted for it by that majority. Now, even if it goes to the governor's desk with those majority kind of numbers, the governor can still veto it. So it's a separate act to override the governor's veto that happens later in the legislative process. So even if they have 163 of all 163 members vote yes on a bill, the governor might still veto it. And if he does, we will still have to come back and get 120 members to vote in support of overriding the governor's veto, because they're separate legal questions. And quite frankly, some people are uncomfortable overriding the governor's veto. They might view it as his constitutional right or authority to veto a bill, and they're unwilling to sort of violate that constitutional authority to veto a bill.
So they probably all want to be governor.
Well, yeah, or they want the governor to sign their bill next year, and
right.
To override the governor's veto might be problematic if that
right.
happens. So,
right.
That's part of the reason why it's a separate question. So a supermajority is the number of people required to override the governor's veto in the legislative process. And since 2014, I believe, the Republican Party has had the number of votes required in both the House and the Senate to override any governor's veto if they chose to. So we saw quite a bit of that in the last couple of years of Governor Nixon's governorship. We have seen less of it since 2016. We did see a few vetoes overridden when Governor Greitens was in charge. But now that we have Governor Parsons, there seems to be a bit more productive communication between the Republican majority of the legislature and the Republican governor's office. So the likelihood of having bills vetoed or the likelihood of having us override a veto seems to be lower. There's a little more consilience between the Republican supermajority now and the Republican governorship than there was 2 years ago. So that's essentially a supermajority, is the ability to get something done without having to worry about what any of the input from the minority party might be.
So how do you get legislation passed?
I make friends.
Yes.
That's the name of the game of politics. And I said it before, that getting a bill to pass is a lot like amassing the number of votes that are necessary to win a majority in a regular general election. It's about addition. You find things that you can agree with people on. You find issues that you work with them on, and you plan your amendments strategically. You talk with them. You get the support of them. A lot of folks think that what we do is go down and fight and stand up and shout and holler, and in some cases that is necessary. In some cases that is the right thing to do. When I was first elected in 2016, I went down for the 2017 legislative cycle, and I pointed out that there was a billionaire in Joplin that was giving out very large campaign contributions to have a lawsuit, to have rules changed that would have resulted in the dismissal of a lawsuit that was filed against him, a class action lawsuit that probably would have damaged his company. I pointed that out, and I did a lot of standing and shouting on the floor then, and it had less to do with a specific policy position and more to do with the overall ethical message that we were sending to our voters about how this process is done, about what it even looks like when people are allowed to file bills as legislators once they've received very substantial campaign contributions from individuals who stand to benefit from the bills that have been filed. And I worked together with a lot of Republicans because I was surprised to find the amount of support that I got when I stood up and pointed that out. So there's a time and a place to stand up and shout and to be that advocate or that kind of advocate. But one should exercise discretion in doing it because the opportunities for doing that are actually far less abundant than the opportunities for coming together on an issue that everybody agrees on, working constructively together to get a result on it, and then passing a piece of legislation that we all can agree is about as good as it's going to get. It's remarkably like being a criminal defense attorney. In other words, most of my cases I go in knowing that the prosecutor is probably able to prove something against my client. Can they prove the crime is charged? Maybe, maybe not. Let's take a look at the evidence and see. Can they prove a crime? Well, they wouldn't have filed the case if they didn't believe that the individual is guilty and they didn't believe that they could prove their case. So when we go in, I work a lot of times to establish where we can get agreement and where we can't. And sometimes it's clear that we can't come to an agreement and we have to set a case for trial. That happens occasionally. But sometimes we can look at the facts and say, this is what makes sense. This is also in my client's best interest. This disposes of the case for him, puts him in a situation where he can move on with his life. He takes what's appropriate and just under the situation and he moves on and quite likely doesn't have to go to prison. And the state gets justice for the people of the state of Missouri, because that's the job of prosecutors, to seek justice for the people of the state of Missouri. And, we come to some sort of, not necessarily an agreeable result, but a result that we can all agree to. And that is very much like the process of good legislation from the minority member's perspective. But in order to get them to listen to you in the first place, you have to have built a personal relationship where they understand where you're coming from and they trust you. It's difficult to do that when all you ever do is shout and, sling insults and, come at it in a combative way. That's not very helpful for the legislative process. It's a lot of working together and it's a lot of building personal relationships.
One of the ways of something to become law is a petition initiative in the state of Missouri, where you get enough signatures, and it has to do with districts, and there's a lot of details that go along with it. But basically, you get enough signatures, and then you just it goes to a statewide vote. Mm-hmm. One of those initiatives this year was in 2018 was the Clean Missouri bill, which did some campaign finance reform, did some reform on how boundaries are drawn, passed overwhelmingly by the state of Missouri. Now, what happened to Clean Missouri in the state legislature this year? Did anything happen in terms of, did that legislation get changed or altered in any way?
But that is a very good question, because the answer to that is yes and no. The House is responsible.
Such a lawyer answer.
Well, it has to be. It must be. In order for me to be completely honest about it, it must be.
Yes.
So the House gets to make its own rules. In other words, the operating rules of the House are voted upon by the House members. Part of what Clean Missouri did was open up quite a bit more information with regard to emails digital information, any kind of data that we keep as state reps, opened up a lot more of that type of information to be subject to a sunshine request, Section 610 of Missouri statutes. Now, because the House gets to make up its own rules, it made up rules that would have exempted us from the sunshine requests that were enacted by the Clean Missouri provisions. So, by virtue of the fact that the House is constitutionally entitled to make its own rules, they made rules that overrode the constitutional mandates about what applied to the sunshine law requests or not. So in an interesting sort of way, they made an end around the changes to the sunshine requests. There were attempts to change contributions to campaign accounts. There were attempts to change contributions or gifts purchased by lobbyists. All those measures failed. There was an attempt to change the provisions in Clean Missouri that would have altered the way that district lines are drawn. And those measures all failed under statutory terms. So am I happy that those measures failed? I am, because I believe that, the will of the people was clearly demonstrated in that election. Whether or not, a person has grounds to disagree with some of the decisions that were made, or, individual voters might have felt differently about it, I certainly understand and respect those positions. But when you have 60% of the people that vote in support of the provisions of that bill, one certainly has to take that into account. I mean, if I thought that it was bad legislation, or if I thought that the voters had made a mistake, then the same logic might very well be used against me to say, well, maybe the voters made a mistake about you holding this office and you should be recalled. Right?
Yeah.
We trust them to elect us.
Right.
We certainly should trust them when they do their ballot initiative petitions as well. That's the whole point, is that the sovereignty of the state is vested first and foremost in the people. And when they tell us that this is the law that they want, that's sort of the law of the land, or it very well should be.
All right. So as a state legislator, you are, I was going to say confined, but that's not the word. You get the opportunity to serve for 5 terms. Is that correct? 10 years?
It's 4 terms, 8 years.
It's 4 terms.
Then,
okay.
Once you've got your 4 terms, you have the opportunity, if you've been elected to 4 terms in the House, you can have the opportunity to run for a different state office. So you could have an additional 2 terms in the Senate. They both add up to 8 years. A Senate term is 4 years and a House term is 2. So you can do 8 years in the House, and then on top of that, do 8 years in the Senate, which is not uncommon. Senator Holzman has done that from Kansas City. I know Senator Sylvie would have done that had he not moved on to the Public Service Commission. It's not at all uncommon for members to do that, and it's a pretty regular occurrence where somebody goes 8 years in the House and then moves on to 8 years in the Senate. You can also do 8 years in the House, then 8 years in the Senate, and then get elected to one of the constitutionally established statewide offices and do an 8-year term there as well. So you could move from the House to the Senate to, say, lieutenant governor or governor, and do an additional 8 there. And you can stack any one of those up. So you could do House 8, Senate 8, lieutenant governor 8, governor 8. But each office has its own limit capacity. So we have a shelf life in that job, so to speak.
And you served post, you never served when there wasn't any term limits.
No, I've always had term limits.
And some of the criticism of the term limits is that it gives lobbyists too much power, that the lobbyists know too much. They have the more institutional knowledge rather than senior legislators. What is your interaction with lobbyists? And I'm going to say this with the caveat that we sort of have a sneering time when we say lobbyists, when there are lobbyists for foster care kids, and there are lobbyists for a better environment, a cleaner environment, climate crisis. Mm-hmm. Sort of the lobbyists that seem to get in the news are the ones that are advocating for corporations. And that it has a negative connotation, but there are lobbyists down there that are fighting really good fights. Tell us about your interaction with lobbyists and how you interact.
There are certain lobbyists who I've known because of my time in the community. So that, for instance, my district has Ford Motor Company's manufacturing facility in the district. So the Local 249 is the union that's there. They have close to 7,000 active members in that union, and Ford Management. And they have a lobbyist for their industry as well. So Ford Motor Company and the union both have lobbyists, and I know them personally. I knew them personally before I got elected, and I regard the lobbyist for the union especially as a personal friend of mine, in terms of being able to sit and talk with them about issues, about personal matters. I mean, if they're a personal friend to you, then that was a friend before you were elected, that relationship doesn't ever change. There are other lobbyists that I did not know at all, had no idea that such an industry would even have a lobbyist when I got to Jeff City, and was surprised to find that, as you said, there are lobbyists for virtually everything that there's a law about. And in my experience, occasionally they'll have information that's good, and I will take the information and read it, and use that as a basis to go and start educating myself on the issue on my own, so that if a bill comes up, they'll have a packet, papers, documents, testimony, things like that, and they'll give that to a legislator. And it's incumbent upon us as legislators to do our job and to read what they've offered us, and then to use that as a basis for doing our own further research. And in doing that, occasionally you find that what they've offered you is not reliable, or you find that what they've offered you is reliable. And as you go through that process, you begin to understand, just like in any other profession, that there are certain lobbyists that are trustworthy people that are not going to lead you astray. And just like being a lawyer, there are certain lobbyists that might present their information in a way that's far more beneficial to them than what would be fair. And you begin to be skeptical of the information that they present to you. And those, just like lawyers, those lobbyists often don't last long. Because so much of it's built on personal relationships, I will take the information that they give me and I will read it, but I will not use it as the sole basis for making my decision. It's never something that I rely on exclusively. Being the ranking member on the Insurance Policy Committee, for instance, I've developed a very good relationship with the Missouri Insurance Coalition lobbyist. I speak with them about a lot of issues, and we agree on very few of them. But that doesn't mean that I won't listen to what he has to say and understand that he has a perspective and he has a client, so to speak, that he has to advocate for. I have my constituents that I have to advocate for and make a decision that I think is in the best interest of the people of the state of Missouri. That doesn't necessarily mean that there aren't legislators who are less diligent in the bills that they file or in the information that they believe from lobbyists. And so there has been an increase in the influence of lobbyists in Jefferson City and the influence that they've been able to get bills passed or certain issue items addressed. I think that by and large, term limits are a good thing for legislators because it requires that we go back home and live with the laws that we've made. In a lot of cases, it prevents so-called career politicians from staying there and becoming too complacent. However, having said that, it's important that people remember that there are term limits, and that when they make their selection for their preferred candidate when they go to vote, that they're making that selection based upon the candidate that they think has the most integrity and the most ability to stand firm for what they believe in the face of what a lobbyist might try to persuade them to do one way or the other.
When you were campaigning just in 2018 and as you gear up for 2020, what are the issues that are facing your district? What are the things that people are talking to you about that are priorities for them and that they want to inform you and have you work on?
Jobs. And at the end of the day, I think everything comes back to jobs. Public education is funded largely by the state budget, but why do we want good, strong public education? Because we want our kids to be well educated enough that they can go to a trade school and get a good job, or they can go to college and get a degree and then get a good job. The public schools employ an awful lot of people, and those are jobs in the district that are paid by our tax dollars, and we want those jobs to be good jobs, but we want them to be cost effective as well. Healthcare. The biggest reason why people are unhappy with leaving the job that they don't like is because they're afraid that they won't be able to find healthcare. Well, the economic drivers, the entrepreneurial spirit is somewhat dampened by that. And when an entrepreneur goes out into the community and he makes a company, or she founds a business or opens a shop that employs more people, we have an opportunity to grow more jobs. At the end of the day, everything comes back down to jobs. And right now we have the largest employer, the largest single employer in my district is Ford Motor Company, and they're in the middle of contract negotiations with their unions. What I'm most concerned with is making sure that Ford Motor Company stays there, but at the same time, the people that work for Ford Motor Company are paid a wage that will continue to support our community in the way that they have. Everything, at the end of the day, comes back down to protecting and enriching people's job and their work environment so that they can continue to support our community. They can continue to pay taxes. They can continue to have good public schools. And they can continue to have roads and bridges paved. So they can continue to have health insurance. So that they have the time to be able to go to city council meetings, to participate in government. And all of that comes back down to having a good, well-paying job.
That's awesome. I mean, that's a good answer. How do you, when you are running, raise money? Like, what are you doing to try and fund your campaign? And I know that state rep campaigns can be, it can run the gamut.
They certainly do.
In terms of some people are up on television and some people are not. Tell the viewers what your fundraising looks like. And this is all the nice part about the government is we can find out who Mark's donors are by going to the Missouri Ethics Commission, where he's not, we're not trying to hide the ball. I just want to hear what you do.
Well, anybody can look it up. It's called the Missouri MEC, the Missouri Ethics Commission. You can go online and find the information. And the name of my fundraising committee is the Friends of Mark Ellebracht. You can do a name search by committee, and you can find out who has donated and in what amounts they've donated. You can find out what I've spent money on, where I've spent it. And you can check the MEC for lobbyist gifts. As far as I know, you're going to find that number to be 0 because I have received no lobbyist gifts that have not been reimbursed back to the lobbying firm. There was one incident where somebody bought me an iced tea that I didn't realize they were a lobbyist at the time. So I gave them the $2.38 or whatever it was back. And then there have been a couple of opportunities to speak at attorney events where I have reimbursed them afterwards for whatever the cost of that they fronted for me to come and speak to them was. And I reimbursed them for that expense, sometimes out of my own pocket because it's just easier, and then sometimes through campaign funds because that's kind of what they're for. But as I said, if somebody wants to take a look, it's Friends of Mark Ellebracht. That's my campaign contributor, my campaign account name. My fundraising mostly is calling up people that I know, who I know are my friends, and asking them to make a contribution of their hard-earned money. So there are a lot of lawyers that contribute to my candidacy. In fact, I would not be where I'm at if it weren't for the contributions made by lawyers that are very much like me in private practice, in a small firm or in a medium-sized firm in some cases, that write checks to me. And it's, usually checks $250 to $500 at a time, which is a lot for some people, and it's not a lot for some other people. So some people can afford to do that, and it's really not noticeable at all. And for some people, that amount, it hurts. But I always try to remember that is the place where my financial resources come from. And I respect the fact that they trust me enough to give me money for me to be able to go down and advocate for my constituencies. The other big place where my funding resources come from are labor unions, mostly because they like my position on their ability to maintain their integrity in the bargaining process with management. Not that I'm anti-management, I'm just very much pro-labor in terms of what I think is apt to get the most fair result in the bargaining process. In other words, I'm anti-right to work, and I believe that labor unions offer the best opportunity for employees to collectively bargain and get the best package of pay, benefits, and time off from work and vacation time that they can get. So I do get quite a few individual contributions from individuals who are not attorneys. I don't self-finance most of my campaigns because I can't afford to self-finance my campaigns. In some cases, as you mentioned, Amy, the races are far less expensive. There are some races where $5,000 to $10,000 raised is going to be more than enough to get the job done. And then there are some races where you're going to need north of $150,000. I know that in 2016, when the seat was open, I was running in 2016 against a candidate who had received $150,000 from David Humphreys down in Joplin to try to win that seat for a pro-right to work candidate. And in terms of staying competitive, I had to come close to trying to match her dollar amount. I believe that in that cycle, she outspent me, but not by much. We worked very hard to match her dollar for dollar, and we worked even harder to go out and knock on doors and do lit drops and get our message out in the mail. So we were able to win in that race. We were able to be successful, but it was largely because of the contributions of the attorneys that helped me get there, the labor unions that helped me get there with both their financial contribution and their the work that they put in knocking doors and doing lit drops, and the help and the individual support of members of my community that trusted me to be the candidate that they preferred in that race.
There was a time where there were lots of lawyers in legislation in Missouri and Kansas. That number has dropped. And I am an advocate for it because I feel like and of course, legislation is made great. The legislature is made great by many different voices.
Sure.
But there are lawyers. The lawyers can bring the unique perspective of the ones that are going to be litigating the laws and being very familiar with the laws. Do you, as a lawyer and a legislature, are people looking to you for input in terms of, hey, how is this going to play out? In terms of that.
Well, I've always tried to be as honest and as upfront with the members that I serve with as possible. I always try to demonstrate as much integrity as I can. And I feel like I have built up a reputation with both the majority and the minority party of being somebody who might be trusted when it comes to asking how stuff like this might work. And I do tend to agree that having a background in law is helpful in certain areas, but I also know that the voices of all different types of backgrounds should be heard. The question I find myself asking a lot, at least to myself, is when somebody has a proposal for a new piece of legislation or a change that they want to see, the question I often find myself is, okay, what are these jury instructions going to look like? And then I work my way back from that. So especially when it comes to criminal or civil litigation, when they try to do tort reform or when they try to do criminal justice reform, the first question I'll always ask myself is, okay, how do these jury instructions work? And then I formulate that into trying to make a conversation with the bill sponsor, who often is not an attorney, and try to have a conversation with them about either making it workable in terms of how it's going to be applied in a courtroom, or how it's going to be interpreted when we have to submit those instructions to a jury and ask them to make a determination of whether or not that law was broken. Try to shape it in such a way that it will more closely conform to how we're going to use it in a courtroom. There are other situations or other times when I look at a piece of legislation and say, okay, this is marvelous, but there's no penalty provision at all. There's really you're making a law that has that you're creating a potential violation of law that has no punishment and no remedy. And what is the purpose of that? Are we just passing laws for the sake of having words written on paper? Or are we, making the guidelines, the sort of the bumpers on the bowling alley, so to speak, of how folks in Missouri are going to go about their daily lives? And sometimes we're able to make changes to bills, and sometimes we're not. And usually in those situations, the bills don't make it to the finish line. Sometimes they do. Sometimes bad stuff happens. Sometimes we fight as hard as we can to prevent something bad from happening, and it happens anyway. I remember Senate Bill 43 that repealed most of the Missouri Human Rights Act was done in 2017, and that was probably one of the most odious things that I could have imagined happening. I was very disappointed in that, and still am. I would like to work to see some changes to right that ship and bring sort of the wheel of justice a little more centered on that one.
Will Clean Missouri change the way your district is drawn?
I believe that Clean Missouri is going to change the way everyone's districts are drawn. Okay. And I say that because the second most important factor in the way those districts are going to be drawn now is what they call competitiveness. And I have to admit that was one of the issues that I myself was a little confused by. I understand that a lot of people think, including myself, that the districts are drawn in such a way as to favor Republican candidates. And in the climate Missouri has been in for the past 10 years or so, drawing those lines to favor Republican candidates has resulted in Republican landslides, not just a Republican edge, but a very dramatic Republican edge. What I think that indicates to me is two things. One is that the boundaries of those districts do matter. The districts are drawn in a way to favor Republicans to a certain extent, because when we have a state that Barack Obama lost by fewer than, I think, 4,000 votes in 2008 to go to a state, and that year, I believe we had at least half, if not 2/3 of the statewide elected officials were Democrats, and yet still ended up with a Republican supermajority in the legislature. That causes one to raise an eyebrow. That doesn't seem like that math works out quite right. Having said that, it is the case, though, that some districts in some areas of the state of Missouri are very, very Republican, and some are very, very Democrat. And drawing a competitive district out of some of those areas is going to create districts that are curious looking. And when that's the second most important factor, competitiveness, behind protecting communities of interest, it also gives me a little bit of concern to wonder what's going to happen to some of our communities of interest where we have majority minority districts, and it's important that we have a Black legislator from that district or Hispanic legislator from that district, because they have a different story to tell, and it's theirs to tell. It's not the provenance of a legislator who would just vote the right way to go and tell their story. It's not the life that they lived, the experience they've had, and therefore the legislative process is less rich for it. So those are the concerns that people have expressed about it, and I think they're real concerns. I do think that in the majority of districts that we have, districts that look like mine, that look like Central and Eastern Jackson County, that look like Platte County, I do think that those districts, which is, in all honesty, where the majority of the House votes come from, are the suburban districts around the two large metropolitan areas, I do think those could be drawn to be more competitive, because by and large, those are predominantly white Christian districts that have been drawn in such a way as to favor Republicans, at least slightly. And bringing more fairness to that map might result in a more balanced state government. So yes, on the one hand, that's the one thing that I think we can take away from that supermajority of Republicans. The other thing that I think it's important for folks to remember is that the Democratic Party has not been doing a very good job of communicating its message about advocating for the jobs of working people and the jobs of the middle class, and trying to find a way to improve their lives by making sure that their employment situation is fair. We have been in a pretty bad process of selecting and advocating on divisive policies. And as I've said before, politics is about addition. And addition is a very, very, very slow process. It takes a long time to develop the trust that is required in order to get someone to believe in you enough to send you to Jefferson City or to Washington, D.C., or to the presidency of the United States, any of those things. It takes a long time to build that trust. It takes a long time to add a vote. They have to very much trust that person. And it doesn't take much at all to divide the voters. And once they're divided, they're far less likely to vote for us. And if we stick to issues that we can add more voters and occasionally come across a vote multiplier, then we do ourselves a service. And if we advocate for or present as a priority to the voters issues that tend to be more divisive, I think we're going to continue to see the Democratic Party dwindle and lose power in the state of Missouri.
I think that is a great point to end on. I do. And I've heard Mark give that message before, and I am in very much agreement with it, that Democrats in Missouri should be talking about kitchen table issues, jobs, school, and healthcare, basically. And that then those are messages that Democrats do better on, that we are for more for people, but the message has been diluted, so we need to get it back on track. I think your constituents are lucky to have you. I am lucky to have you as a friend, and I definitely support him. And I want to have you back on the show to talk about your law office.
Sure, I'd be delighted.
But I really wanted to get in here and get in some nitty gritty about how laws are made, and just to get give for my clients and the viewers of my channel to understand how it works better. And I think you were the perfect person to do that.
Thank you. I'm flattered that you asked me to be here, and it's been a pleasure. Thank you.